Hello, everybody. Welcome to the next training session of loss prevention. We're going to talk about, in this video presentation, this is actually going to be a re-presentation based on PowerPoint I did with Kirk on one of the other shows. Going to try to narrow this down a little bit and make it without all of the normal commentary we do on the show. So kind of dig right into it. Subject matter of this PowerPoint is American Jurisprudence, Volume 37, Fraud, Deceit, and Fraudulent Conveyance. Hopefully by the time you get to the end of this, you'll have a little bit better understanding about why I spot fraud as easily as I do. Because if I can help you in any way, it is to be able to help you duplicate my eyes and ears for yourself so you can spot these things as easily as I do. One of the reasons I chose American Jurisprudence for this particular presentation as opposed to going through Mason's, Jefferson's, Roberts, whatever, was because when you make a presentation, many of the persons to whom you're going to be presenting recognize this information. So you'd be speaking in their language, right? So before I get into that, this is basically me. I am the Chief Executive Officer, CEO for short, of this company. I started this company in 2017 to do this purpose. And one of the things that we are working extremely hard on with reference to the foreign emoluments clause is a weakness that we found even in the law dictionary, right? So chances are there's been a extremely large effort to keep this out of the eyes of the court. So if there's a word, a phrase, piece of evidence, whatever, that somebody will go to great lengths to hide, one of the first things you have to do is you have to, number one, figure out what that is, and it's not always the easiest thing to do. The second thing is you need to study it implicitly. Because again, as I said, the persons to whom you're going to be making your presentation are very well practiced in the art of never asking a question that they don't already know the answer to. Okay, so fraud, deceit, and fraudulent conveyance, basically here's the scope of it. I've always defined it as, the black hole, right? Because it really is. I mean, in my former life, any fraud, deceit, deception, whatever, it was literally the kiss of death to any, not just any company, but any actor who was involved in it, right? These bad actors make it a way of life. So not to put too fine a point on that, even some of this information is also incomplete due to the fact, I'm going to show where we're talking about here in just a minute. But, excuse me, if you're thinking about relief and remedy, okay, well, again, we know as we petition the legislature, because that's due process, right? It is what it is. So you establish your right to a cause of action through remonstrance, and ultimate resolution. Now, I pronounce it remonstrance. I prefer that pronunciation for one simple reason. Anybody who's ever read one of my 1,000+ page reports will refer to them as monsters. So hence remonstrance. So anybody who's making jokes about that, well, again, that's kind of my little bit of logic as far as my personal preference and why. So when you're making your presentation before a political body, right? Now, we're not getting into a court yet. We're just talking about a political presentation. One of the things that you get asked is, what is your interest? So we're going to talk a little bit about what your interest is and how that's defined. First principle of group decision making, jurisdiction, right? It can't be given. It has to be agreed upon through the quorum. That's the proper establishment moving forward based on your subject matter, right? And because the jurisdiction is going to dictate what court it is. So what jurisdiction or court applies and why through your state's legislative manuals, right? And of course, as you know, multiple states use multiple manuals. Florida uses the preferred here in Florida is Jefferson's and Mason's. Mason's first, Jefferson's second, depending on what process. So, and my personal favorite question being, what emolument is that again? Right? So it's, this was kind of, when you're talking about something as basic as interest. I'm beginning with the Webster's Collegiate Dictionary because this is usually the one where most people would go to their parents' house, pull a dictionary off the shelf and look for a definition. Why? Because not everybody has access to a law dictionary. Some of the law dictionary definitions are going to be presented as I go throughout this. So looking at the basic definition, I'm going to start with definition number 2 here, which is a charge for borrowed money, generally a percentage of the amount borrowed, right? So, and of course, B, the profit in goods or money that is made on investment or capital or invested capital. So knowing and understanding when you're getting into special interests, right? We get into like reciprocity agreements, right? The corporate dog Latin version definition 3, right? The advantage and benefit, right? Well, you don't think of benefit as being an emolument, but it is coming from the 13th century root definition, as we've talked about before. So the word benefit is actually, technically speaking, an emolument, right? Well, that would be a self-interest if you're looking at it from that perspective. This is part of one of the ways they create these circular arguments, hence the special interest, right? So how do you avoid that? Okay, so again, these are tripwires, some things I'm trying to help you to understand. So when you look at the very bottom there where it says interest from 1608, to induce or persuade, to participate or engage, right? And number 2, to engage the attention or arouse the interest of. So as you go forward, chances are the average person is looking at it through the 1608 definition, right? So again, one of the reasons I asked the question, am I on or off the clock with respect to interest, because when I'm on the clock, I'm looking at definition number 2 as I showed up here, right? And then, in the, I don't know if you can see my mouse, but oh, there we go, over to the right. So, when I'm on the clock, I'm here. When I'm off the clock at home, I'm down here, right? So again, I go back to that, am I on or off the clock question a lot. So looking at this from the current Black's Law 11th edition. Now we can argue and bicker over the validity of Black's Law Dictionary and what its intended purpose was to be technically a fraud in and of itself, right? Hence one of the reasons I cite it as a source. So to go into where you start here, start with the second definition. And here's why, because this is a legal share in something, okay? All or part of a legal or equitable claim to or right in property. Collectively, the word includes any aggregation of rights, privileges, powers, and immunities. Distributively, it refers to any one right, privilege, power, or immunity. So, reason I say here, because when you're talking about persons in position of emolument, hence these hence these powers, privileges, immunities, and all of this garbage, the legislature is the place to make this argument, right? To establish that you're here, you've got an actor sitting in whatever emolument, domestic or foreign, and you want that person removed because of X. Okay, so many of you will go default to interest of justice, right? Again, another very common use of the word interest. What's your interest in this case? Well, it's in the interest of justice, right? The average person reading the second definition from the Webster's Collegiate Dictionary, obviously your brain would go there. That makes logical sense. The other three, legal interest, legally protected interest, and of course, liberty interest. Now, liberty interest is where you need to focus, because this definition from 1960 is an interest protected by the due process clauses of the state and federal constitutions. See, fundamental right. This is where you are going to begin with claiming and ultimately exercising your rights, right? Whether they're constitutionally protected or God-given or any combination thereof. Okay, because as Kirk so aptly always says, it's the rights are the law. So your interest in your rights as the law. So this would be your most, even court decisions refer to, many cases as, a person has a liberty interest in X, whatever X might be. So if the judge is going to say you have a liberty interest in that, right, stands to reason you might say, well, walk into the legislature and say, well, even the judge says right here in this case, in his opinion or her opinion, the court views this as a liberty interest, right? So that's a good way to start that, because now you're going in and you're saying, hey, I support this judge, right? I agree with this. So tactically speaking, it's a smart play if you're looking at this from a tactical vantage point. So again, as mentioned before, in the 10 principles of group decision making, this comes from Masons. And as I said, jurisdiction must be given. It cannot be assumed, right? These pretended acts of legislation, right, are a result of groups sometimes assuming powers they do not have. It is what it is. This is what you're litigating, and this is what you're arguing. And as I've said, these people are very arrogant and they're very practiced at this. So just know that this is what you're headed for, right? Hence my reference to not knowing, the answer to a question before you ask the question, right? Because that's where they'll trip you up. And they'll know it by the look in your eyes. They're very skilled at reading hand signals and body language. So jurisdiction of this office, as many of you have already, learned, is under Title 28 of the United States Code, Section 1443. This specifically goes to the two criteria on the screen in front of you. Okay, so when you can walk in and you can prove a negative, basically, for example, a Brady violation, you have a document or a piece of evidence that would be exculpatory in a criminal case. Fundamentally and principally, this establishes what's called reasonable doubt, right? So, there's no way that I could have been involved in whatever X crime. I was, You know, I have a video surveillance photo of me 10 miles away getting gas, right? I mean, that's just a loose fitting example of a way to provide exculpatory evidence. So, ironically, we needed a jurisdiction for this. So, and here's the reason why. Okay. A lot of people ask me, why are you engaged in dealing with a lot of these jackwagons? That's a very good question. Because while I was at work, right, in my domestic emolument, Article 1, Section 6, Clause 2, I know what the law is. I wouldn't know, I don't know any other way to do this. Hence the reason it's, you know, loss prevention being literally the backbone of every major corporation on the planet. So, in so much as practicing law, in quotes, domestic emoluments is the only thing I know. The fact that there's this definition number 2, the foreign emoluments clause, has never even had a definition in the dictionary. Oh, well, yeah. So basically, we have one set of men operating from the fourth pillar of law. And here comes this another set of men who operate from the fifth pillar of law, which creates a nexus between the two pillars. Well, that's a jurisdiction foreign to our form of government and unacknowledged by our Constitution, according to the Declaration of Independence. So, in Article 1, Section 6, Clause 2, as domestic emoluments go, okay, again, if you've watched the market video, this is a slide from that video, right? The Constitution represents, the United States Constitution is represented by the red lines, right? Supreme law of the land are up, minimum standard of due process or down, right? That's basically establishes your margins, okay? That's where you operate. You know, color inside the lines. If you can't color inside the lines, you probably don't want to try this. So your state constitution is an even narrower mechanism. That's the reason it's double yellow line, ironically utilizing the road, right? So when you're talking about postal roads, okay, the average, you driving down the street and you see 2 lanes going one way, 2 lanes going the other way. That's a quid pro quo and a reciprocity, basically a what for what and an equal return, right? That is the free flow, free exchange, right? So, letter of the law states, Congress shall make no law impairing the obligation of a contract. Sounds reasonable, right? Well, let's look at the way what these streets and highways would look like once you start to implement these foreign emoluments in foreign jurisdictions and things that the average Joe doesn't recognize. Those appear as government monopoly markets with little to no reciprocity, all managed by foreign emoluments working from pillars of law, violating Article 1, Section 9, Clause 8 of the Constitution's Foreign Emoluments Clause. Right? A republic and the republic structure, okay, it's with 3 pillars of law. Each pillar has a branch attached to it, right? Legislative branch, executive branch, judicial branch, 1, 2, 3. What branch you're working in dictates the process. Nothing says you should know all 3, right? I've just never messed with judiciary because I never had these problems. You know, like my buddy Kirk says, you know, you don't have to smash your finger with a hammer to know that's going to hurt. Well, apparently some people needed to smash their finger with a hammer. How, you know, what else are you going to say? So basically, when we pointed all this stuff out in the shift made up impeachment, as I call it, you know, and the court correctly dismissed the Democrats' claim of the use of the emoluments clause against the president, and ultimately, fundamentally, why the courts correctly ruled as they did invalidating Title IV and Obamacare in context mandating full repeal. Again, watch the markets video. I totally explain all that, so I'm not going to beat everybody up again with this. But looking at this from the standpoint of a diagram, right? You know what a road and you know what a street and highway is. So, you can't open up markets with no reciprocity. That's not done in this country. So, back to interest. In so much as, for generally speaking, you walk into a courtroom, American Jurisprudence, Volume 37, referencing fraud, deceit, and fraudulent conveyance. So here it is, generally speaking. The right to recover interest in an action based upon fraud has been upheld in actions for damages for fraud and deceit, inducing the plaintiff to purchase or exchange property, in actions for damages for depriving a person of his property by means of fraud and deceit, or fraudulently inducing him to sell it, in actions based on fraud relating to a wrong done to a plaintiff's property or his possession thereof, or brought to recover money wrongfully received, obtained, or detained, right? In action for fraud inducing a loan or investment of money, right? And in other actions to recover damages for fraud under various miscellaneous factual situations. So it's this section right here, okay, where you're going to primarily focus right after the number 18. And in other actions to recover damages for fraud under various miscellaneous factual situations. So generally, no distinction is made in so far as the right to recover interest is concerned between the employment of the benefit, quote unquote, benefit of the bargain rule, right? And the quote unquote out of pocket rule. Methods of measuring the plaintiff's general damages, right, are basically going to be pretty much as follows. So without going through and reading every bit of this, there are specific areas in here, and the reason I'm making this available to you is because there are certain areas of slides that I'm going to call special attention to as you're going through this when you're talking about recovering personal property or chattels, right? Real property, that's another whole process that would require, much of my real estate licensing, training materials to go through all of that. So let's just stick with chattels, utilization of American jurisprudence, and of course the Hobbs Act as property is defined there. So moreover, kind of give you an idea where I'm at here is number 9, right here where my mouse cursor is to the right over here. Moreover, the applicability to actions based on fraud of the exception to the prohibition against the allowance of interest on unliquidated demands, which is sometimes raised where the damages are capable of ascertainment by computation or by reference to generally recognized standards for the fixing of values, has been frequently recognized. Okay, so again, if you wish to be recognized moving forward, once you've established what jurisdiction you're talking about, okay, these are key areas you want to focus on, right? Because you say, look, if we have a pattern for this already, we're not doing anything different than we've already done in the past. So quit your crying, right? It is what it is. There is some authority to support the conclusion that in an action based on fraud, interest may be allowed, right? So now we're talking about general interest, compounding interest, whatever. That's interest related to money, not liberty interest. So in the proper circumstances, as a sort of penalty for the defendant's wrongful conduct, right? So a lot of people go, well, this has been ongoing forever, and I think it's compounding damages, so the interest should be compounding. Simple logic and reason would take your brain there, but then again, when you've actually ever set in a position where you've actually had to, collect an account, compounding interest is not a smart way of going about this. Hence the reason we've been having so much difficulty with compounding interest loans for real property. So keep it simple. Pick a number and go, right? Don't keep changing your mind, because that'll throw you right out the door. Even, and I'm no judge, and I'll be the first one to tell you, if somebody walks into my office and starts that, I boot them, right? Because you can't, hence the letter of the law, right? Congress has the power to fix the weights and measures, right? So once it's fixed, leave it alone. Okay, does that make sense? Excuse me. So go back here. Although there is some English authority to the effect that the fact that an action for money had and received is based on fraud is not enough to remove the case from the general rule that interest will not be allowed in such an action except under special circumstances, such as showing of an express promise to pay. Okay, so if you don't have an express promise to pay, you again leave the interest out of it. Instances are not lacking in which the propriety of allowing interest in an action for money had and received, which is based upon the defendant's fraud, has been upheld. Again, if it's been done, we've got a pattern here, right? So reading and briefing some of those cases would be prudent. In suits to recover payments made under a contract induced by fraud, pay very close attention, because this here is very important. Whether brought in equity to secure a rescission of the contract, or at law after a rescission, in payas is, by act of the parties, right? The allowance of interest on the recovery granted is generally upheld, although some decisions indicate that under certain circumstances, interest will not be allowed. Again, look for this word, okay? If you see the word not in there, do yourself a favor, shy away from it. Because, in context, it could end up tripping you up in the process, right? You want your resolution to be smooth and by the numbers, because if it's smooth and by the numbers, enforcement of it, it's easy, right? That would be a lawful contract that is easily enforced. So there is also authority indicating that a plaintiff is not entitled to recover interest during any period where it appears that he had actual possession of the property with respect to which the action was brought. Aha. Right? So if you ever had possession of the property, and somebody will say, well, you had it for, 5 days, right? Leave the interest out of it, because when they make that argument, you can specifically say, objection. Defendant is attempting to enter facts that are not in evidence. There's no claim for interest. That would be an interest. He's trying to introduce an interest standard or an interest rule when we're not even talking about interest in so much as money is concerned, financial transactions related to chattel, personal property. So again, these are things that you really need to kind of pay attention to, because when you get into relief and remedies, right, and of course general jurisdiction, fraud of all kinds is abhorrent to the law, right? And it is a general principle that if one person sustains injury through fraud, the fraud of another in any form, the courts have jurisdiction to afford a proper remedy, right? So section 323 here You say, well, you don't have standing. Yes, I do. Go to American Jurisprudence, Volume 37, subsection 323. It's right there, opening sentence. So the fact that it also appears in the ninth principle of group decision making, okay, you see what I'm saying here? This is a way for you to implement, right? When if you're beginning as the defendant by plea or exception becomes plaintiff, hence in Latin, res excipiendo fit actor, okay, this is one of the reasons why when I spot fraud and I hit him with that, in so much as the question of what emolument is that, they typically fold like an accordion. Brady violations notwithstanding. So starting down here towards the bottom, the fact that the state has an interest in protecting its citizens from fraud and imposition and and may regulate matters of domestic trade by enforcing obedience to a statute through punishment of offenders, right, does not exclude any civil remedy to the person injured. Okay, so they're going to say, oh, well, the state's protected and blah, blah, blah. Well, guess what? Again, that's why I say, you'll hear me say, I don't care about that. I don't have a dog in that fight. This is the type of thing I'm talking about. When he specifically says, does not exclude a civil remedy to the person injured. If that's you still have the right to remedy, claim your cause of action, right? So in equity jurisdiction, when you're talking about personal property chattel, okay, it frequently is said in a general way that ground for equitable relief exists in, or that equity courts have jurisdiction over, cases arising out of fraud, misrepresentation, concealment, fraudulent suppression of material facts, bad faith, or breach of trust. This is, again, Amjur 37, section 324. Okay, so we're going to talk about the English law, talk about English doctrine. So when you're talking about, you'll hear us say even on the show, what law, if you're going to take a statute, you're going to make a reference to a law, what law? And the 99 times out of 100, they can't even name the law. They'll rattle off that statute, but what law is that statute connected to? If it's not connected to anything, it has no standing. Not that statutes have any standing anyway, hence Peterson versus Peterson. So the statutory argument becomes moot at that point, right? So, you'll hear me say a lot of times when people get into statutory word salad disputes, I'll say, you want to go litigate statutes, you go do that in front of a mirror. Don't waste my time. Here's what the court says about statutes. They're not law. So if they're not law, they've got no standing here, right? It's a way to shut down the word salad. Say, focus here. You want to focus and stand in the common law. Don't let them pull their statutory smew on you, because don't think that they're not going to try. So as we move forward, some stuff here. Don't think it's necessary. Effective remedy at law, right? Many of you have read The Negative Nexus. You've heard me say, cause of the thing causing is the cause of the effect. So what's the effect of remedy at law? So while it is a general principle that equity has jurisdiction in fraud cases where there is no adequate remedy at law, there is some difference of opinion as to the effect of an adequate remedy at law upon the jurisdiction of equity, right? You'll hear us even say it on the show. How are you going to make me whole again after how many years? Are you kidding me? I always recommend watching the Hardwick versus Orange County and Vreeken case on what's available here on YouTube. You can literally watch the judge just pounds this bar member over thinking that they have the right to lie. I mean, it's just talk about makes your brain, melt. So the generally prevailing view in the United States is that the equity court will not exercise its power if the law affords a complete remedy. For example, an affirmative defense, right? Fraud is an affirmative defense, right? See, this can actually start to become circular if you're not careful. A case according to this view is not within the jurisdiction of equity if the remedy at law is complete. Damages only being sought on account of the alleged fraud. Again, another reason why I say stay away from interest, meaning money, not in liberty interest. That's why I said establish the modifier of your interest being liberty interest, not money interest. So, and the court of law being capable of affording all relief that is properly obtainable on the ground of fraud. Okay. Again, you'll hear us say, is it brought proper before the court? Well, if it's brought proper before the court, you can properly obtain it, right? Means you can enforce it, you can collect it. So, let's see, the prevailing doctrine, the American courts, no, yeah, I'll leave it. That's why I said this slide's going to be in here. I want to go to directly whether fraud was practiced presents an issue of fact which can be determined in an action at law as well as a suit in equity. Okay. One of the mediums of this issue is, for example, where fraud may be interposed as a defense to an action at law on a contract. The defendant is not entitled to have the issue as to fraud tried in equity, right? So again, if you're going to use it as a defense, you can't turn around and use it as a potential prosecution, right? Hence, when you use this in the legislative mechanism, only to remove this person from their emolument, right? That gives you, and Kirk correctly says this, you take that person once they've been removed from that emolument, right? That's when you take them into the judicial branch and sue the crap out of them. One of our buddies says, what's the square footage of your house? Because I need to know if my furniture is going to fit. So, again, that's the proper way to handle it. So, when you look at the letter of the Constitution, it says, the legislature basically is the place to go to remove a person from a position of emolument, right? Somebody in a position of privileges or immunities. So as long as they're acting in their official capacity, right, and they're acting in good faith, and they can clearly articulate why they think they're acting in good faith, right? You probably don't have a snowball's chance in hell, which is one of the reasons why you have to take your process, begin it through the legislature, and you serve the court. So, for example, I get this question a lot. Which is the reason I'm bringing it up here, in distinctions between equitable relief and legal remedies for fraud. Okay. For example, I walked into court and I tried to tell the judge this and that, and he wouldn't take my evidence. That just gave you a right to a cause of action to lodge a complaint against an actor sitting in position of emolument, right? Go tell on them the way Kirk says it. Say, look, I have Brady information here, exculpatory evidence. I went to present this, and the dude sitting up there on the bench said he wasn't going to hear it. Is that a reasonable person? Right? Hence the reasonable person standard. So you can take a lot of their word salad and beat them over the head with it if you know what you're doing. So, it becomes a simple question of, and a parliamentary inquiry, what reasonable person would exclude exculpatory evidence, knowing that there's actual case precedent. It's called Brady versus Maryland, 1963. Can somebody here in this quorum, right, reasonably articulate to me why this person is still sitting in this emolument, knowing and understanding that this is exculpatory evidence and quashes this case? Can somebody explain this to me? Right? I mean, it's a proper question brought properly before a political body, right? Because I can tell you right now, on an up and down vote, unless of course we're talking about, the foreign emoluments who are starting this crap, right? You're probably not going to get anybody voting yes. Hence the reason, the president's recent, live stream or rally, he talks about this stuff. So, watch some of his rallies. He'll tell you what voting Republican means. But anyway, I digress. Alternative remedies election. Okay, because when you're talking about remedy, right? What is your perception of remedy? Your perception of remedy might be referred to as an alternative. Again, you don't know that. Hence the reason we're going through this stuff. So generally speaking, in pursuance of the rule that a contract or transaction induced by fraud is ordinarily merely voidable, a defrauded party is, upon discovery of the fraud, put to an election. The legal system offers him a choice of several courses of conduct and remedies to redress the effect of the fraud and false representations, right? The misrepresentation. He may elect whether to proceed ex contractu or ex delicto, I'm sorry. Accordingly, he may elect to affirm the transaction and sue for the benefits to which he is entitled thereunder, or for damages for deceit, keeping any consideration received. On the other hand, he may elect to disaffirm the contract, frequently doing so by electing to rescind and to be restored to his former position, recovering money paid out or the consideration or liability on the ground of constructive fraud, such as would afford no relief in law, especially by means of an action for deceit. So again, some of these things that's why I said you got to be very careful about how to avoid the circular argument, and don't think that these people aren't skilled in doing it. Many of them have been doing it for generations, right? So this is why I tell you, stick to your talking points and hand a copy of those talking points to everybody, right? Whether you ask the parliamentarian to make copies and distribute it to the members when you go in for oversight. Ladies and gentlemen of the body, you've read my talking points. Before I begin, do we have any questions? Right? Get their engagement right out of the box. Because if they have questions for you, I would rather take my time and answer their questions knowing that they've just read my talking points. Why would I waste my time before the body reading what they've already got a copy of? Right? So again, tactically speaking, getting the engagement, right? Another simple question is, number one, do we have any questions? Number two, is there anything else you need from me before we begin? Right? And come prepared. So, this is why I said, you can take control, right, of your situation just by knowing, for example, these two terms. Excuse me. Ex contractu is Latin from a contract, arising from a contract. Ex delicto is Latin, basically arising from a crime or tort. So looking back at the section in the book here, right? Those two terms that you're probably going, what did he say? I've taken the liberty of defining those for you. So again, I know and understand not everybody has studied Latin and the legalese the way I have. So hence the reason I put them in here for you. The choice of remedies available to the defrauded party may be narrowed by an election of remedies or by conduct which constitutes a waiver or estoppel of the right to assert a particular remedy, or even all remedies. So again, spend some time putting a lot of these things together as you read through your document, right? Are you proceeding as, as a defendant to quash a case? Are you proceeding on an impeachment, basically a prosecutor to rip somebody out of that emolument so they can be tried as a man, right? If you're going to do that, also know and understand you're probably not the only victim. Hence the reason I've said it in every one of my cases. Here in Florida, in 2018, the people voted for this law. It has nothing to do with the courts, got nothing to do with the emoluments of this company. It has nothing to do with my jurisdiction. And here's what the people voted for. People voted for the victims having rights. I agree with that assessment. Well, now that victims have rights, Lady Justice is now the victim under this foreign law, right? This foreign Sharia law. That ideology believes that women are property. Well, guess what? If justice here in America is observed and the common observance of justice is referred to as Lady Justice, Lady Justice is now the victim and victims have rights. So if you want to fight for your liberty interest and knowing that justice comes before liberty, fighting for Lady Justice's victims' rights, that's a pretty good solid strategy to start with. So, because remember, like in my case, what was the worst thing they did to me? They put me, they threw me into general population, and I laughed and played cards with the guys for a few days. Woohoo! Because guess what? Everybody I was sitting there with, we all had that same damn problem. That frickin' Muslim sitting in the frickin' bench calling himself a judge. Huh. No, you're not. I digress. This is all going to be in the book, by the way, the fifth pillar. So section 328, result of effectual choice. Okay. So based on the two choices on those two terms that we talked about, this kind of outlines what the effectual choice would be. Okay. So I'm, again, I'll just limit it to this section right here. The bringing by a defrauded party of an action to recover the property parted with by him constitutes an election to rescind, right? So in other words, well, I just want my property back. So then you would want to proceed, right, with rescission. Well, of course, there are many ways to rescind, and there are many people that have done many wonderful things with rescission. So again, I say, look up multiple people before you even begin to try to do this, right? Because there are people that specialize in just rescinding, right? There are people that specialize in specific types of contracts, right? Hence the reason I was talking about real property contracts. That's a different type of contract. So that's within the scope and authority of the emoluments of my actual business license that I carry. So originally licensed in 1999, I think it's one of the 7 danger signs. I've been doing this job for a while, hence this next section on sales, right? So in the reference to real property. So for those of you who are having issues of real property, right, I left these sections in this presentation not to go through them, as a major kind of a talking point. I'll probably reuse this PowerPoint in the next video, and I'll start from probably right about here when I go through and I impeach bad real property transactions using specific cases, right, as good examples and good ways to articulate your claim to go in there and say, no, You can take your freaking fraudulent, foreclosure and go, jam that where the sun don't shine. So, let's see, legal relief for actions at law generally. Okay, so we'll start here at section 330. So the jurisdiction of the law court, or in states where law and equity are heard by courts of general jurisdiction, like, for example, Ohio uses what's called a common pleas court, okay, of the law side of the court affords relief in cases of fraud on many of general bases on which actions at law are founded. Okay, so again, this is another one of the ways that I articulate in law versus at law. Okay, because if you're standing in law and your action is at law, okay, an actor acting from a foreign pillar or foreign emolument, right? The fact that there's no definition of Article 1, Section 9, Clause 8, hence there's no remedy, right? Does this make sense? So without going into a huge monumental explanation, sticking with ex contractu or ex delicto standards, again, generally justified and appropriate, right? Unless, of course, you wish to participate in 28 USC 1443. And I'm going to nail them down on these foreign emoluments, these actors acting from foreign pillars of law, thinking that they are just God's gift and nobody can touch them. No, you're not. Anyway, I digress. So this goes to, and of course, now in my world, when I'm talking about this in the issue of a quorum, okay, so determination of nature or kind of action, right, immaterially of name. I'm sorry. Yeah. Anyway, excuse me. Because we have no definition, we have no basis from which to start. Still requires a quorum, because this is going to be lawful business. You can't conduct lawful business without a quorum. So hence the reason, I've never included a board of directors, even in my domestic emolument, never had to include the board of directors, hence Congress, in on a research project. That's why I said this is literally new territory for every one of us. And I mean every one of us. So this is, I say when these actors walked in and scamming and frauded their way in there, and everybody's like, yeah, duh. Okay, well, again, this is why I always say, looking at the code, 0 times 0 at the center of my litmus test, 0 becomes an improvement, right? They walked in here, laid claims, wrote up their fake bonds, their monopoly money, and all of the crap that they do, right? And it's all junk. It literally is. This is what a monopoly game over looks like, right? So normally you think of when monopoly's over, you just clean up the mess and put it back in its box, stick it back in the shelf in the closet until you're ready to play again. Hence the reason I think we're closed down, because guess what? Are we going to set up the board and play again, or what are we doing? It's a good question, isn't it? So particular actions, section 332, actions for damages of deceit, right? A lot of people confuse fraud and deceit. So you may end up finding yourself beginning in fraud and going back to a tort action for deceit, right? While you redress the fraudulent actor or the fraudulent action, which removes him or her from their emolument, yay, your claim against the actor isn't for fraud, it's for deceit, using a position of emolument advantage, right, for whatever they used it for, to steal. Yeah, fundamentally and principally, we know darn well we can't do that. Hence, that's why I always joke, have you ever read the Constitution? just for, just for the sport of it. Have you ever read the darn thing, much less ever tried to figure out what relationship it is to domestic emoluments and markets? The stuff didn't just come from nowhere. It had to be built somewhere. So, that's why I said the things that you take for granted, even my granddad used to say, if I could remember half of what I forgot, I'd be fine. So, in order to sue for deceit, a defrauded party is not generally required to rescind a contract into which the parties may have entered, or to offer to rescind it. Excuse me. To return or offer to return what he has received under it, or if the contract involves the acquisition of property, to pay the residue, if any, of the consideration which he is giving for the property. Personally, I think that's deficient, right? So if it's deficient, okay, yes, it begins to touch in on it, but still, excuse me, this is why, as we said in the beginning, when it comes to fraud and deceit, under fraud and under deceit, it goes in multiple different directions. Only some of them we have just now begin to touch. So hence the audit. So for fraud or misrepresentation in sales, okay, use section 333. Again, this goes to the real property stuff, which I'm going to kind of skim right over here. And this will be, as I said, this is on the Patreon site for you guys. So the effect of warranty or covenant. Okay. Now, warranty, real property being like a warranty deed, right? Or a covenant. That would be for those of you in family law. Give me my kid back or I'm coming in here with my gun to blow you in half. Right? Let's just call that spade a spade. Don't tell me you weren't thinking it, because we both know you were thinking it. I've been thinking it, and I'm not going to deny that. So, so basically, let's get into just kind of the last sentence here. The injured person may bring the deceit action, especially where it would cost him time and money and loss of use of the subject matter while the defects were being remedied under the warranty. Right? So, again, stay the hell away from insurance issues, because they'll try to, oh yeah, just settle with the insurance company. Yeah, no, let's just be done with this, because we already know what a nullity is, right? That's already happened in the legislature. What the hell were you guys thinking when you passed this garbage? Right? That's attempting to legislate for us in all cases whatsoever. Again, have you read the Declaration? So, and the chances are, and 99% of them never did, because it wasn't taught even in basic civic class, wasn't even taught in basic school. Freaking foreign emoluments. So an action, as some said, an action for money and received recovery of consideration. Okay. So if you've been dismissed and kicked to the curb, right? Remember, even Sir Patrick Henry said, we have been spurned from the throne with contempt. Our repeated, and of course the Declaration says, our repeated petitions have only been met with repeated injury. Okay. Just knowing where these things come from in history makes you a formidable enemy, especially to a bad actor. Because when you know more than they do, it's extremely intimidating to a bad actor. So, thus a defrauded party who in accordance with law has rescinded a contract by act, right? That maxim of law. An action taken by me against my will is not my act. Okay. May come into a court for all the relief which such court is competent to give him. That's pretty much the short answer. So, what court is of competent jurisdiction if we haven't even defined foreign emoluments yet? Still requires a quorum in totality. That's why I always say, one of the reasons why I avoid courts and I avoid that whole monstrosity, there's no competent jurisdiction. Hell, we've never even defined it. How can you claim a competent jurisdiction of something we've never defined? Because you got foreign emoluments came in and took over the damn courtroom while we were at work all day long. Get the hell out of here with this garbage. Hence my my constant joking about that whole sovereign citizen nonsense. So basically what you're saying is I can be on the clock and off the clock at the same time. Walk in there and tell your boss that. I'm clocking out and going home, but you still got to pay me. see how long you have a job. So recovery of property or its value. Okay. This is, there are multiple ways to do this. I've done it replevin. Replevin is actually my favorite because many even county courts have documents posted, processes posted for writs of replevin, right? So there's even an outline for it. So, detinue, trover, or statutory substitute, if you want to get involved with a bar member and go litigate for another 10 years, have at it. But I don't recommend it because once you're litigating in court, now you're, you're out of the, your ability to litigate in the legislature. So that's why I said you got to get that actor out of that emolument first. That's the first thing you got to do, right? So equitable remedies, generally speaking, right? So in so much as generally speaking with its usual facility, equity affords many remedies for the redress of fraud. The remedy most frequently employed in equity to secure relief from fraud is that of rescission, which frequently results in the cancellation of some instrument which interferes with, destroys, or transfers the rights of the defrauded party, or, if uncanceled, would result in a legal indebtedness or obligation. So if you're looking at the last half of that, you could end up in another freaking circular argument. So you have to be very, very careful of how you're dealing with actors who are really skilled at circular arguments, right? It's the most bizarre thing I think I've ever seen in my life. Sometimes what I'll do is I'll make them get engaged in it, only because I'm smart enough to know how to break the circle, which is one of the reasons why I'm teaching you guys how to do this. Because if you know how to break their cycle and break their circle, they're the ones who sound like they're a freaking illogical moron, whether they're in a position of emolument or not. Again, what reasonable person could conclude? We're talking about a conclusion here. Perpetuities are contrary to the genius of free government, right? Hence a lot of our Texas members. So kind of go into, here we go. Equity will refuse its aid to enforce or sustain a fraudulent contract to the prejudice of third persons. Relief will not be accorded if the rights of an innocent persons will be jeopardized. Right? That's why I say, when you're, litigating in as a third party, right? Third party practice, well, knowing and understanding that the Bar Association, working from the fourth pillar and practicing Islamic law, those are already third and fourth party actors. So, again, negative destroys a negative and both make an affirmative. So hence the implementation of the negative nexus. You see what I'm saying? There are many ways to utilize mathematics, geometry, algebra, multiple sciences to really just beat these guys over the head with stuff. So generally speaking, rescission, this is the power of jurisdiction of equity with respect to relief against consequences of fraud, is most frequently invoked to secure the rescission of a transaction, agreement, or contract infected with fraud. So in legislation, you'll see poison pills. They talk about that a lot. In such cases, as a court of equity usually grants the defrauded party the full relief to which he may be entitled under the premises. So another reason to leave the interest out of it, right? You go after the principal, get that actor removed from that emolument. You take what belongs to you, okay? And in so much as interest goes, hey, guess what? There's going to be 10 other people out there who are going to need some kind of relief and remedy that you will never even know exist. So, depending on the quality of your work product, will depend on how many people actually will get assistance for whatever it is you do. So, as we resolve, hence the hint, hint, wink, wink, nudge, nudge, following due process being that of resolution. You've heard me mention this before. The name of the desk the president sits behind, the resolute desk. So, in accordance with the general principles governing the rescission of contracts by the act of the parties and cancellation of instruments in equity generally, hence the bonds, partial rescission on the ground of fraud will not ordinarily be permitted in equity if a contract is entire and inseparable, since such a contract cannot be affirmed in part and disaffirmed in part. So here's when we're talking about affirmation or disaffirmation, if we, again, go back to the weakness, the deficiency, what emolument are we talking about? Article 1, Section 6, Clause 2, or Article 1, Section 9, Clause 8? And this is where you cue the Jeopardy music, right? And the bad actors know, by the way, they know where they're at. Article 1, Section 9, Clause 8, which is why I try to hide it. Injunctive, injunction, right? Injunctions are very popular for securing chattel, right? Hey, give me my property back, you jackwagon, right? And that is usually referred to as injunctive relief, right? So, that's hence the reason it's the opening sentence here. So, let me see. Fraud is a defense. I'm going to focus a little bit on this because this is kind of important. Under modern law, let's talk about modern law, right? We're not talking about modern law. We're talking about the common law here. We're taking you back to the legislature, right? You're what they're calling modern law. That's statutes and codes and all that foreign emoluments, right? So that's why I say there's utilizing all that stuff as a defense, saying, well, the simplicity of this is this jackwagon is purporting that statutes are law. Well, the judge has already said how many times statutes are not law, right? So hence the reason, without a definition, there is no remedy. That's, I think it was Sampson v. Murray. Don't ask me to remember the year. It was in my original Monopoly challenge. Again, I knew this way back when. There can't be a remedy, because that's what Sampson v. Murray is. It was basically an establishment of a right to proceed where there's no adequate remedy at law, or even in law for that matter, or in equity. Because if we don't have even a dictionary definition, How can there be any remedy in law, at law, or in equity? So I said, maybe you want to write these questions down, because when you go in and you start beating them over the head against these foreign emoluments, these are pretty good political questions, which is one of the reasons why I like doing this. So at early common law, fraud in the execution of a deed or other sealed instrument was available as a defense in an action at law. Hence the reason fraud is in the Federal Rules of Civil Procedure, 8C1, right? Fraud and statute of frauds. So that's how these things ended up in the federal court rules, right? So knowing the origination of what happened, how that thing actually came into being, law of creation, right? Is Federal Rule 8C1, technically speaking, potentially deficient in its defenses? If there's no definition of what Article 1, Section 9, Clause 8 constitutes as a foreign emolument in the eyes of the court. Right? That's why I said Lady Justice is the victim here. So, recoupment or counterclaim. It doesn't say recoupment of counterclaim. Pay attention. It says recoupment or counterclaim. Pick one, right? So, this is why I say a lot of people will say, "Oh, just give me the recoupment." Well, I'm going with counterclaim because I want the whole truckload. I want all these jack wagons out of here. I'm not leaving my kids to suffer the same crap that I suffered that was handed to me by my parents, right? That ain't happening. You know, they didn't want to pick up the ball and roll with it. Trust me, I will. So basically now you're going to get into measure of damages, and I'm going to kind of cut this off right here. But again, just sort of the general is, you know, it's simple. The measure of damages for fraud is as a general rule the actual pecuniary loss sustained. So if we're talking how many years of your life, you know, to kind of boil that down to a sentence, if that's at all possible, is that acceptable to you? I don't think it is, but at least gives you a place to start. So I hope this video helps you guys understand what it is I do, how it is I do it, and why many of my days and nights at work were extremely long, right? It was very difficult. It's going to be very difficult to do loss prevention without a definition of what constitutes a foreign emolument moving forward, right? So in protecting domestic companies, we need this definition. If I'm going to go back and take my position, go back to work, right? I can't do the job for my company that they hire me to do if I don't have the tool in my toolbox. Does that make sense? So again, thank you for watching. And I hope you found this content helpful, even if it was for review purposes only. So, you know, thanks for watching, everybody, and hope to see you on the show real soon.